Case 1.
Okay, well, we're on the record in the matter of the people of the city of Lansing versus Dane Lamond Alston. File number is 22-02907. Council appearance.
Your Honor, I'm not ready to go on the record yet with him. I have to talk to him about the offer. I have talked to him before, but I was gonna get in a breakout room with him before on the record. Thank you.
He's in room 4.
Mr. Staples did meet with Mr. Bird.
I'm trying to understand why we have so much stuff in here too. Fine. Remember GCE in here. See, oh, here it is. It's back here. Yes. There are Darren Regulus here. Okay, that's you. You can come up to the table here. We are on the record in the matter of Calvary SPV LLC versus Darren Regulus. File number is 14-04097 GC. Council appearance.
Good morning, Your Honor. Michael Bankstein, P 697778 on behalf of Cavalry SPV LLC.
Thank you. We have Mr. Regulus present here in court. Today was the date that was scheduled for a review. We were here back on August 1st. We granted the defendant's request to make payments in the amount of $50 per month. Have you been making those payments, sir?
Yes, Your Honor.
Okay. So I set it for a review to see if there was a reason to increase the payments. Has your financial situation changed since the last time you were here?
Not really, but my plan, I'm trying to knock it down and go ahead and get them out of my way. I got it down to $590.
Okay, you owe about $592. That accurate, Mr. Bankstein?
I'm showing a balance of $642.24, although it's possible that he's made a payment that has not yet posted.
Yeah, that's right.
Okay, he believes that's accurate, that he's made a payment that's not posted yet. Okay, so at this time, I'm going to continue the payments as is. He says, or he reports to the court that his financial situation has not changed since August, which was only a few months ago. I don't see any reason why I would need to increase it. He's making those payments on time. Hopefully he'll get it paid off, and then we'll get a satisfaction filed by the plaintiff.
Your Honor, I just wanted to put on the record, it's my client's position that defendant should resume paying $75 a month, but of course, I'll, respect the order of the court.
Thank you. That is noted for the record.
My plan is if I can get it down to a little bit more, I'll just take a whole paycheck and just get them out of the way.
Okay, I think he's making a good faith effort to get it resolved. And I don't want to bind him up in a situation where if something happens within the next couple of months that he defaults. So I'll continue payments as they are at this time. Any additional matters for the record?
I have nothing further, Your Honor.
Anything for the record, sir?
No,
Okay, you're all set. Thank you.
thank you.
Thank you, Your Honor. Have a great day.
You're welcome. You too. Ms. Donnelly, are you ready to go on the record?
Yes, Your Honor, thank you.
Okay. Okay, record in the matter of the people of the city of Lansing versus Dane Alston. File number 22-02907, council appearance.
Matt Staples for the city of Lansing.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Dean Alston, who is appearing separately from the Union County Jail.
Today was the date that was set for a pretrial on a furnishing false information. How do we want to proceed on this matter?
Your Honor, at this time, there is no offer from the city of Lansing. Mr. Alston would plead as charged.
Mr. Alston, is that correct? You want to plead to the original charge of furnishing false information?
Yes, ma'am.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am. I swear.
Thank you. You can put your hand down, sir. Okay, Mr. Alston, you have the following rights. You have the right in this matter to proceed to a trial, and you have the right to have a jury trial. At the time of trial, you have the right to be represented by counsel. You have the right to the presumption of innocence, which means you are innocent until proven guilty beyond a reasonable doubt. You have the right to have the city bring sufficient evidence to prove each element beyond a reasonable doubt. You have the right to see, hear, or question any witness the city may call against you. You have the right to call your own witnesses at trial or present evidence that you believe would further defense of the charge. You also have the right to remain silent at trial and not have the silence be used against you. In order to plead guilty to the charge, you have to give up each of those rights today, sir. Do you understand that?
Yes, ma'am.
And you want to give those rights up?
No, ma'am.
Okay, so we can set this for a trial, okay?
No. I don't want to set it for a trial.
We say you didn't want to give up your rights.
Oh, well, I misunderstood you. I misunderstood you. I don't want to set it up for a trial. I just want to see you.
In order to plead guilty, you got to give up the rights.
Okay.
Mr. Alston, your
Sarah
trial
Donnelly,
rights, your trial rights, you have to waive them. You have to waive.
Okay, yeah,
going to trial.
okay.
Not all your
Right.
rights, just trial rights and.
Yeah.
Okay, and so is anybody making any promises to you to get you to want to give up these rights today?
No, ma'am.
Anybody threatening you to get you to waive your rights?
No, ma'am.
Are you currently on probation?
Yes, ma'am.
Have you discussed whether or not this will have an impact on your probation status?
I did discuss with my attorney. Yes, I did.
Okay, very good. And you understand that a guilty plea can result in a conviction that may have impact on your employment status, or you may need to report a conviction to your future employer. You understand that?
Yes, ma'am.
You also understand that a guilty plea can result in a conviction that may have impact on any immigration status that you may be seeking.
Yes, ma'am.
Okay, and understanding that you want to plead guilty today,
Yes.
and you're pleading guilty because you believe you're guilty?
Yes.
Okay, as to the charge of furnishing false information, how do you plead?
Guilty.
Guilty, not guilty, you plead guilty, okay. On or about October 25th, 2022, approximately 9:46 PM, were you in the area upon East Michigan Avenue at or near Lark Street?
Yes,
Is that in the city of Lansing, Ingham County, state of Michigan?
Lansing,
Is that in Ingham County?
Ingham County, Michigan.
Okay, and so.
Yes.
I'm sorry. Okay, and did you have an interaction with law enforcement at that time?
Interaction with what?
Did you have interaction with law enforcement, with a police officer?
Yes, I did.
Okay, tell me what happened that made you guilty of furnishing false information.
He walked upon me. I was eating and he walked upon me. I was eating a burrito thing that I got from Myers, and he walked upon me. I was in the parking lot and he walked upon me, and he just asked me my name, and I gave him a false name.
He just randomly walked up to you and asked you your name?
Yes, he just drove up on me and asked me my name, asked me who I was, and I told him that I gave him a false name.
Back door.
Okay, any other factual basis?
No, Your Honor.
None for the city.
Court is satisfied with the factual basis. I'll accept your plea if you may plea voluntarily and intelligently. How long has he been in custody?
Your Honor, he's been in custody since he was arrested October 25th.
Okay, now credit time, sir, close the file. You're all set, sir. Do you have any questions, sir?
No, ma'am.
Okay, you're all set. I'm crediting you time served.
All right, thank you.
You're welcome. Mr. Gatesman? Mr. Gatesman, are you there? Mr. Alston, you're free to go.
I am here, yes.
Okay, Mr. Gatesman, which matter are you here for?
Bradley? I had emailed the video clerk. I think we have something worked out, but I wanted to chat with the city attorney.
Well, let me get some people cleared out of the courtroom first.
Can I also have an email? Do I need to email you a advice of rights? I have one. I think if we resolve it.
You can send it to Judge Simmons Courtroom at lansingmi.gov. Okay, Mr. Bird, do you have an attorney? You do not have an attorney? Okay, have you met with the city attorney on this?
Yeah.
Okay. All right, come up.
Hey, you're right with you.
Did you request court appointed counsel on this?
No.
Okay. We're on the record in the matter of the people of the city of Lansing versus Elmer Dwayne Bird. I have here file number 22-02064. Council appearance.
Matt Staples for the city of Lansing.
Okay, Mr. Bird, you're proceeding today without the representation of counsel. You've declined to request court appointed counsel, that's correct?
Yes.
This matter was scheduled today for a final pretrial on an unregistered vehicle. Is there an offer on this, Mr. Staples?
Your Honor, Mr. Bird was able to show to me his registration and insurance when they put him in a breakout room with me. So at this point, the city would be dismissing the remaining charge of drove unregistered.
Okay, so that will be dismissed. And then you had a no proof of insurance and a registration and plate violation that both had a default judgment. Did you take care of those? Yes, you were supposed to be here on the 17th of October. You failed to appear, so default judgment entered. And unless you made a motion to set aside the default judgment, then they would remain there. Are you making a motion to set aside the default judgment?
Yeah.
Okay, I'll grant your motion. You said he's gotten the vehicle registered?
That's correct, Your Honor. He has the proof of registration and his insurance with him.
Okay, so the other matter, it was another registration and plate violation, and then there was a no proof of insurance. Would the city be offering anything on that?
Are those civil infractions, Your Honor?
Correct.
The city is fine with those being dismissed as well.
Okay, these are dismissed. You're all set, sir. Thank you. Have a good one. Thank you, Mr. Staples. Are you here for court, sir? What's your name? Okay, you're represented by Mr. Lee or Ms. Donnelly? Okay, sounds good. And ma'am, are you here for court? What's your name? Paulette Pender. And are you represented by Mr. Lee as well? Okay, sounds good. Okay, I see a Shamika.
Yes, ma'am.
What's your last name, ma'am?
Best, BEST.
Which case number are you logging in on, ma'am?
See if it says it on the top of this piece of paper. I'm here for Villeresquez property. 220312 1 LTE.
Okay, I know for sure that that can't be scheduled for today because we don't do landlord tenant today.
Oh, well, maybe I'm ahead of my, do apologize.
Yeah, does it have a date on your form that you were supposed to appear?
Actually, I just grabbed this out the car because we're at Sparrow with my son, so I thought it was today. I do apologize and did not mean to
Let me see
interrupt.
here. She has a warrant. You do have a warrant, so you need to turn yourself in on that, ma'am.
For what? Sorry.
Income, failure to pay income tax.
Okay. I'll come down and take care of that.
Okay, you see your LT case with her? That could be on.
So do I just call to get the correct date?
Oh, we're gonna give it to you right now. We're looking up the file.
Thank you.
You
And
said
when
it
I,
was 22-0312.
yeah, let me pull this one back up. 22-0312. Yes, ma'am.
Yeah, you're missing a number.
22-0312. Is this a 1? I think 1 LTE.
Right, does mine? 22-0.
3121.
You put 131. It's the 9th at 9:15.
Okay. And when I come down there, do I just go to the ticket spot for this warrant?
Yep, you'll go to the counter and let them know that you have a warrant you want to get taken care of.
Okay, thank you again, and I do apologize.
No problem. We'll see you on Wednesday.
Bye-bye.
Okay, on the record, in the matter of the people of the city of Lansing versus Antonio Xavier Garcia, file number 19-03993, council appearance.
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Mr. Garcia, who is standing to my right.
Okay, how are you, Mr. Garcia?
Very good.
Today was the date that was set for a free trial and open alcohol in public. How are we proceeding on this?
Mr. Garcia is ready to plead guilty to the open alcohol charge. We do have a Killebrew agreement in place with the prosecutor.
Let me guess, it's no upfront jail.
Yes,
We don't put people in jail for that here.
ma'am. I didn't even go to jail the night they gave it to me.
Yeah, agreed.
I mean,
It's not, it's a fake killer. Okay, you want to accept the offer, sir?
Yes,
And plead
ma'am.
to the charge. Can you raise your right hand? You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury. You can put your hand down. Mr. Garcia, although we're not inclined to put people in jail for these types of charges, this is a misdemeanor that you're being charged with. And because of that, you have the right to proceed to a trial. And you have the right to have a jury trial, or you can have a non-jury trial. At the time of trial, you have the right to be represented by counsel. You have the right to remain silent and not have silence be used against you. You have the right to the presumption of innocence. So that means you are innocent until proven guilty. You have the right to have the city bring enough evidence to prove your guilt beyond a reasonable doubt. You have the right to see, hear, or question any of their witnesses, or call your own witnesses that you believe would further defense to this charge. So you would need to waive each of those rights here today if you wanted to plead to the charge. You understand that?
yes, ma'am.
You do want to waive those rights?
Yes, ma'am.
Have you completed an advice of rights?
Yes.
Okay, can you have them complete an advice of rights, please? That just outlines the rights I just went over with you. You want to review and sign that. If you have any questions, we're here to answer them, okay?
Yes, ma'am.
Who's doing arraignments today? Is it the magistrate?
Should be.
Okay, so do you have any questions about your rights at this time?
No, ma'am.
Okay, you understand that a guilty plea could result in a conviction that you may need to report to your employer.
Yes, ma'am.
It also could be something that may have an impact on any immigration status you may be seeking.
Yes, ma'am.
You still want to waive your rights and plead guilty?
Yes, ma'am.
Okay, you're pleading guilty because you believe you're guilty.
Yes, ma'am.
As to the open alcohol in public, how do you plead, sir?
Guilty.
On or about September 15, 2019, at about approximately 5:33 p.m. in the area of South Washington Ave in East Lansing. Well, were you present in that area at first during that date and
Well,
time?
they got it wrong because they said East Lansing. I mean, I was right down the street, South Washington, Lansing.
What says East Lansing?
Oh, I thought you just said East Lansing.
No, East South is what I meant to
Oh,
say.
yeah,
If I
yeah,
said East
yeah.
Lansing. Well, so on that date and time, you were on South Washington at or near East South.
Yes, ma'am.
Is that in the city of Lansing?
Yes, ma'am.
It's in Ingham County?
Yes, ma'am.
Okay, and did you have some open alcohol?
Yes, ma'am.
What do you have?
Had a bottle of Moet.
It was open?
Yeah, this is my third bottle that day.
You just outside, just popping
Yeah, I
bottles, huh?
just had got out of jail
Celebrating.
and I celebrate I had got out the night before or something. I was up all night celebrating. Then I made it downtown. I was kind of on a homeless thing too.
Got it.
So I went in downtown liquor store right here, got me a bottle, popped that, and then got another one, popped that, went and got another one, and walked down the street to Real Town. They had something going on there, and so I ended up, I was tired at the same time, been up all night, so I sat down in a rocking chair in front of Dave's Furniture and fell asleep,
What you know what?
passed out with the Moet bottle.
Okay.
And I woke up and the police was like, hey, man, and they issued me a citation and told me just to, get out of there.
Got it. Okay. Any other factual basis from the city?
Nothing from the city, Your Honor.
Anything from you, Mr. Lee?
Nothing further.
Okay, the court is satisfied with the factual basis. I'll accept your plea. Trying your plea be made freely, voluntarily, and intelligently. I'm not going to admonish you on celebrating your freedom. Just do it indoors next time, okay?
I was homeless.
I get it. I get it. No popping bottles in the streets, though.
Right.
So nonetheless, your fine is $50. When can you make payment?
$50. I can make that payment the 25th, I believe. It's my father just passed Thursday.
My
So
apologies.
yeah, thank you. And so we have to make the arrangements or whatever necessary. So this check that I got coming this week. Yeah,
We're not
that's-
open on the 25th, actually, because that's Thanksgiving. So how about we go with December 2nd? Does that work?
Yes, ma'am.
Okay, my condolences on you and your
Thank you. very much.
family loss. If you do need an extension, you just need to call the court and let us know before the 2nd, okay?
Okay, yes, ma'am. Thank you.
No problem. Any additional matters for the record, counsel?
No, thank you, Your Honor.
You're all set.
Thank you very much. Thank you, John. Appreciate it.
You are on the record in the matter of the people of the city of Lansing versus Paulette Pender, file number 22-01567. Council appearances.
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Ms. Pender, who is standing by.
Okay, and how are you, Ms. Pender? I'm doing well. Today was the date that was scheduled or rescheduled for your pretrial. We adjourned this 90 days to allow you an opportunity to get a license. Has she been able to do that?
No, she has not yet obtained her license, Your Honor. She is working on it and has begun taking steps to get it. But today is looking to put this matter behind her by pleading guilty to allowing a unlicensed person or suspended person to drive.
What does it mean that she's still working towards getting?
She has been working with the Secretary of State in getting proof of her sobriety. She
Okay.
has received and has with her today her letters of recommendation, character references and such. So she's started to go through the process.
Okay, so the offer was to amend it to allowing an unlicensed driver?
Allowing a suspended persons to drive, I believe was the charge.
He wasn't charged with driving on a suspended license, just allowing, and it was driving unlicensed, correct?
Let me see. You might be right. Might be no arms. So, yeah,
So the
I-
goal is just to get something non-obstructable, is that what the goal is?
yes, we can amend that, Your Honor, absolutely, to failure to display an operator's license.
I'm sorry, you want to amend it, you said?
Yeah, the plea would be to failure to display an operator's license.
Okay,
And I believe that that's agreeable with the prosecutor.
Mr. Staples?
Yeah, allowing suspended revoked would be a 0 point no licensing action misdemeanor that does not abstract as well. So that was that would be 1341. MCL 257.9042 would be kind of the standard one I would use in that place, but certainly no objection if there's a separate charge they would prefer. That's
Well,
the
he
same
just-
0.
Did you? Well, he just ended failure to display ops, but that's not non-obstructable though. That's why I was asking, was the goal for non-obstructable?
We were looking for the non-extractable. Is that not non-extractable? Am I wrong about that?
It would, I know 1341 is non-abstractable.
And that's allowing
A suspended person.
suspended to drive. That's what we had originally agreed upon. That's what we thought.
Yeah, I
So
just
that's
want to
fine.
make sure there was understanding on that.
Yep.
So that's what you want to plead to today, ma'am?
Yes.
Okay, did you review an advice of rights sheet yet?
That's the sheet that-
Okay, and so, Ms. Pender, you have the right in this matter to proceed to a trial. You have the right to have a jury trial. The time of trial, you have the right to the presumption of innocence, meaning you will be innocent until proven guilty. You have the right to have the city bring enough evidence to prove each element of the charge being brought against you. They have to prove each element beyond a reasonable doubt. You also have the right to see, hear, or question any of the witnesses that they intend to call. You have the right to call your own witnesses or present evidence that you believe would further a defense to this charge. Right, and you have the right to remain silent and not have silence be used against you. You understand those rights? Do you have any questions about any of these rights?
No, ma'am.
Okay. In order to plead guilty to the amended charge of allowing a suspended person to operate, you would need to give up or waive those rights today. You understand that? Okay, and you're willing to waive them?
Yes, ma'am.
Is anybody threatening you to get you to waive your rights?
No, ma'am.
Any promises being made to you to get you to waive your rights? And are you pleading guilty because you believe you are guilty?
Yes, ma'am.
Okay, as to the amended charge of allowing a suspended driver, how do you plead?
I plead guilty.
Actual basis, please.
Ms. Pender, on June 8th, 2022, were you driving in your car on Pennsylvania Avenue near Kalamazoo?
Yes, I was.
And that is in the city of Lansing, the county of Ingham, state of Michigan.
Yes, I was.
And at that time, were you driving without a valid or proper license?
Yes, I was.
I believe that the factual basis has been established.
Okay, in Pennsylvania and Kalamazoo, is that a road open to the public, ma'am?
Yes, Your Honor.
Okay, any questions, Mr. Staples?
None for the city, Your Honor.
What happened with the registration? You should pay that. Registration issue. The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. She had a citation for a registration that same day. I don't see what happened to it. Registration of plate violation. Oh, she paid it. Okay, very good. Okay. Your fine is $100. When can you make payment?
Thursday.
Okay. Do you have any questions for us today?
Yes, I'm still gonna get my license.
I hope you do. You need to
I
get it.
will.
Yeah,
I will.
keep making your efforts to do that. You need to get it. And this plea will not prevent you or further push you back from getting the license. So that's good, okay?
Yes,
Okay, keep doing what you're doing.
ma'am. Okay, thank you, ma'am.
You're welcome. Have a good one.
You too. You too. Thank you, Mr. Young. Thank you, Your Honor.
You're welcome. Okay. Mr. Gatesman needs to meet with Mr. Staples. I'm gonna put you both in a private meeting room. Mr. Staples is in room 1. Who's on the Revel V5G? Can you unmute and tell me your name?
Jasmine James.
Okay, Jasmine James. Who's representing her? Do they need to speak with her?
Your Honor, I do speak with Ms. James and I do want to briefly talk to her in a breakout room.
Okay, sounds good. I will put her in room 4.
Sometimes.
Mr. Staples, I'm issuing a bench warrant for Zachary Johnson.
All right, thank you, Your Honor.
No problem. We're on the record in the matter of the people of the city of Lansing versus Samora Nichelle Jones, file number 22-01740. Council appearance.
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Ms. Jones, who is appearing with us via Zoom.
Thank you. Today was the date that was scheduled for a pre-trial. I think we were waiting for an assessment to be completed. So we reset this matter. How are we proceeding at this time?
We did get this, I'm sorry, go ahead. Matthew.
Your Honor, as a preliminary matter, the city would be dismissing the one count of OUICS Schedule 1 related to marijuana due to the issues with the state labs. So that is being dismissed outright and not as part of any negotiations.
So he's moving to dismiss which count?
The OUICS Schedule 1, which is the one related to marijuana due to the issues with the state testing labs.
That's count 2.
I believe so, Your Honor.
Okay. And so the city's proceeding on counts 1 and 3?
Correct, Your Honor.
How are we proceeding?
We have reached an agreement with the prosecutor to plead to the high blood alcohol content charge, the other charge being dismissed with a Killebrew agreement in place for no upfront fee.
Okay, she's just gonna plead guilty to count 1, and then the people are gonna dismiss count 3. And
That's correct, Your Honor.
acceptance of the plea? Okay. Okay, Ms. Jones, you want to accept that offer today?
Yes, Your Honor.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Okay, you can put your hand down. Ms. Jones, in this matter, you have the right to proceed to a trial. You have the right to a jury trial, or you can waive jury trial and have a non-jury trial. But at the time of trial, you have the right to the presumption of innocence. So that means that you are innocent until the city can prove you guilty beyond a reasonable doubt. In order to accept this offer and plead guilty, you would need to waive that right. You also would be waiving the right to remain silent at trial and not have silence be used against you. You'd be waiving the right to have the city bring sufficient evidence to prove each element of the charges being brought against you beyond a reasonable doubt. You'll be waiving the right to see, hear, or question any other witnesses that the prosecution intends to call. You'll be waiving the right to call your own witnesses or present evidence that you believe would further a defense to the charge. And then you'll be waiving your right to remain silent and not have silence be used against you. Do you understand that?
Yes, Your Honor.
And you're willing to waive each of those rights today?
Yes, Your Honor.
Anybody threatening you to get you to waive your rights and plead guilty?
No, Your Honor.
Any promises been made to you to get you to waive your rights and plead guilty?
No, Your Honor.
Okay, are you currently on probation or parole?
Probation.
Okay, who are you on probation before?
Brianna, I do not know how to say her last name.
You're on probation through this court?
54th Lansing, Michigan.
Which judge put you on probation?
I don't really know. I know I'm out on bond.
Okay, you're on bond. That makes sense. And I know Brianna Otten did your screening. But my
Yes.
question was, are you on probation at this time?
Not currently.
Okay. You understand that if you were on probation, a guilty plea could have an impact on your probation status, correct?
Yes, Your Honor.
And a guilty plea could also have an impact on your employment. You may need to report a conviction to your current employer or to a future employer. Do you understand that?
Yes, Your Honor.
Also, a guilty plea can result in the conviction that may have an immigration impact, like you may not be able to visit or gain entry to Canada. You understand that?
Yes, Your Honor.
Okay. And you're pleading guilty because you believe you are guilty?
Yes, Your Honor.
As to count one of operating the high BAC, how do you plead?
Guilty.
Some factual basis, please.
Ms. Jones, is it true that on December 19th, 2021, you were driving on Lyons Avenue near McKim Avenue?
Yes, sir.
And that is in the city of Lansing, the county of Ingham, the state of Michigan.
Yes, sir.
On that date, it is also true that you had been consuming brandy.
Yes,
Is that
sir.
accurate? That as a result, your blood alcohol content was greater than 0.17 as dictated by statute and contrary to the law.
Yes, sir.
I believe that factual basis has been established for you.
Questions from the city?
Nothing from the city, Your Honor.
Are satisfied with the factual basis? I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing is going to be January 3rd, 2023 at 8:30 in the morning.
Will that be in,
Sentencing, I'm sorry,
will that be in person?
that can be, that will be via Zoom.
Okay.
Prior to sentencing, you need to meet with probation so they can prepare the court a pre-sentence report and recommendation. You have already completed an assessment, so you will not need to do a new one. And they will get a report to me. So you should turn yourself into the probation department no later than Wednesday at 10 o'clock in person so that they can get you set up for that interview, okay?
Okay.
Do you have any questions at this time?
I do not, Your Honor.
Any questions? Ms. Jones, do you have any questions?
Thought you heard me. Sorry. No, Your Honor.
Oh, okay, no problem. Any additional matters for the record, counsel?
No, thank you, Your Honor.
Nothing for the city, Your Honor.
Thank you. You're all set, Ms. Jones. We'll see you on the 3rd of January.
Thank you, Your Honor.
No problem. Okay, Mr. Gatesman. Must not be here. I don't have a. Here. Are we ready on Jasmine James?
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the city of Lansing versus Jasmine James. File number is 22-00320. Council appearance.
Matt Staples for the city of Lansing.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Jasmine James, who is appearing separately by Zoom.
Today was the date that was set for a pretrial. How are we proceeding on it?
Your Honor, at this time, there is an offer for Ms. James to plead to an added count of allowing a suspended person to operate. At this time, Ms. James would like the opportunity to get her license. She is anticipating that she'll be able to take her written portion this week. So we would ask if the court would allow adjournment of either 30 to 45 days.
So here's the thing with Miss James. She doesn't like to come back to court.
Your Honor, I do understand that there has been a history of failure to appear. I do know that now that I've had contact with her and, given her the offer, that she is still trying to get a license. So I was just, then this is the first time that she's appeared. So hopefully that all the kinks are out and she's now going to appear is what I understand, Your Honor.
Okay, Ms. James, I have about 4 bench warrants on this file for you, which is not good. It's not favorable for you. I'm always someone that is happy to adjourn a matter to allow you to go and get a license if that's what you're trying to do. But it troubles me when you're someone who doesn't take responsibility for returning to court when you're supposed to. So is that going to be a problem?
No,
Okay. And do you already have an appointment to go and get your license, or are you looking to go and make efforts to do that?
I'm going to make efforts to do that today, probably after I get done with court.
I'm going to reset this for 45 days because if you don't already have an appointment, it's about to be the holidays, so it may take
Yeah.
you some time. You need to remain in communication with your attorney. You need to
Okay.
make sure you come back to court, okay?
Yes, ma'am.
January 3rd must be on fire, but no. At 9:30? January 3rd at 9:30.
Okay.
Okay. Do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing for the city, Your Honor.
None for defense. Thank you, Your Honor.
Okay, you're all set, ma'am.
Great, thank you.
No problem. Oh, I think I need that back. I don't think I put a bond amount. Mr. Gatesman? Mr. Gatesman, can you hear me? You have to unmute.
Sorry, I was trying to. I apologize.
No worries. Okay, so let's see. Is Mr. Bradley there with you?
Yes, he's sitting next to me.
Okay, we're
I
on the
can tell you-
record in the matter. We're on
Good
the
morning.
record in the matter of the people of the city of Lansing versus Brian Dale Bradley, file number 19-03466, council appearance.
Matt Staples on behalf of the city of Lansing.
Mark Gatesman, on behalf of Mr. Bradley, he's present. We're prepared to resolve the matter, Judge, with a plea.
Okay, sounds good. I just wanted to point out, do you work with a Marcus Wilcox? Because that's who our appearance is for.
I do. Mr.
Okay,
Bradley,
sounds-
you're okay with me standing in for Mr. Wilcox today?
Yes, I am.
Okay, sounds good. Today was the date that was set for a pre-trial, and appears to be an offer. Can one of the attorneys state it on the record, please?
Judge, the city attorney has agreed to allow Mr. Bradley to plead to reduce charge of distant OUIL. Mr. Bradley has a concurrent OUIL in Livingston County. He has pled to that for the Livingston County Drug Court. As of last Wednesday, the Livingston County Drug Court approved him. He's been attending the drug court, but he'll be sentenced on that matter later this month. In exchange for the reduction from high BAC to the OUIL, we're asking the court to consider not transferring this case to Livingston County, but perhaps giving him concurrent sanctions for the drug court matter in Livingston County. I've run this request by Danielle Strauss, who's the sobriety court probation officer in Ingham County. Those things have been done before, she informs me, but certainly that's in the court's discretion. I also emailed a substance abuse evaluation to your staff this morning. We're prepared to go ahead with the plea.
Okay. Mr. Bradley, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I do, Your Honor.
Okay, thank you, sir. You can put your hand down. In this matter, you are being charged with one count of operating while intoxicated high BAC, but the people are offering for you to plead guilty to one count of operating while under the influence of a liquor. Did you want to accept that offer today?
Yes, I do.
Okay, you understand that to accept that offer, you have to give up some rights. One of those rights is your right to proceed to a trial. You have the right to a jury trial, and at the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty, sir. You're willing to give up that right?
Yes, I am.
Okay, so that means you're also gonna give up your right to have the prosecution have to prove each element of the charge being brought against you beyond a reasonable doubt. You're gonna give up the right to see, hear, or question any of the witnesses that they intend to call. You're gonna give up your right to call your own witnesses at trial or present evidence at trial that you believe would further defense to the charge. You're gonna give up the right to remain silent and not have silence be used against you. You understand that?
Yes, I do.
Okay. Anybody threatening you to get you to waive your rights to plead guilty to this charge?
No, Your Honor.
Has there been any threats to you at all if you plead guilty?
No, Your Honor.
Okay, and you're currently on, well, I guess through probation through Livingston County, correct?
He hasn't been sentenced yet. He's attending the drug court. When's your sentencing?
It's next Wednesday.
But he's been approved and accepted into the court.
You said next Wednesday?
That's correct.
Okay. You understand that a guilty plea can result in a conviction that may have impact on your current job?
Yes, I do.
You also may need to report a conviction to your future employer or put it on a job application. You understand that?
Yes, I do.
You understand that a guilty plea can result in a conviction that may impact immigration or travel status that you may be seeking. You understand that?
Yes, Your Honor.
Okay. And you're pleading guilty to the charge of OUIL because you believe you are guilty?
Yes, that's correct.
Okay. And I recognize that there's a request to have him sentenced concurrently with whatever he's going to be sentenced to in Livingston County, but I've not made any agreement to do that. You understand that, sir?
Yes, I do.
Okay. As to the admitted charge of operating under the influence of liquor. How do you plead?
Guilty.
Can I have a factual basis, Mr. Gatesman?
Yes, Mr. Bradley, on or about March 17th, 2019, in the city of Lansing, county of Ingham, state of Michigan, were you driving a vehicle?
Yes, I was.
And you were involved in a single car accident, slid off the road, is that correct?
That is correct.
You were taken to the hospital and you now know they drew blood, correct?
Yes, I do now.
And the blood alcohol level was 0.201. We don't dispute that, is that correct?
That is correct.
Your ability to drive the vehicle on that date and location was affected by your use of alcohol, right?
Yes.
What were you drinking that day?
We were drinking beer.
Okay. I think that's sufficient. Is that sufficient, Judge?
Anything from you, Mr. Staples?
Nothing, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. Mr. Gatesman, I know you said you sent over some paperwork. Did you get that paperwork?
Was that a question for me?
I'm talking to my court officer. I don't think we received the email. Did you send it to Judge Simmons Courtroom at lansingmi.gov?
I did, and that didn't go through. So I sent it then to Addie Nash at Lansing, Michigan.
Oh, sounds good. You see it. Okay, looks like we do have it. So I will add that to the file. I am going to set this for a sentencing date after his sentencing in Livingston County. If you can provide us an update on what he's sentenced to there, then I can take that under consideration. I will not be ordering him to undergo an assessment because he already's done one.
Thank you.
Sentencing is going to be Monday, December 19th at 8:30 in the morning.
8:30,
That's correct.
and we could do it via Zoom.
That's correct.
Thank you so much.
No problem. Any additional matters for the record, counsel?
No,
None for the city, Your Honor.
I have one, Judge. I'm sorry. So he's going to be, should I instruct him to reach out to probation in Ingham?
Yes, he's got, but I wanted to get a copy of whatever he's going to be sentenced to over there, so they can provide that with their report and recommendation. I'm not
Yes.
ordering him to do, I am not ordering him to do another assessment, but he does need to contact probation within 48 hours. And I'll allow him to, he lives in Livingston County, correct?
He does.
I'll allow him to reach out to them virtually versus in person.
Thank you.
Thank you, Your Honor.
Okay, Mr. Lee, who do you have again with me?
I have Mr. Kenneth Brown here with me.
Okay, we ready to proceed?
I do need to talk with Mr. Staples briefly.
Okay. Nobody wanted to show up for their show cause today, huh? Yes.
I don't seem to be in the,
I'm not gonna mention you stuff out.
okay.
It causes feedback for us. I'll add him to room 1, Mr. Staples.
Okay.
You gotta do what? Log out of the meeting.
Okay. Did you talk to your client at all?
It's just renewal.
Okay. On the record in the matter of the people of the city of Lansing versus Kenneth Terrell Brown, file number 22-01834, council appearance.
Matt Staples on behalf of the city of Lansing, Your Honor.
Assistant Public Defender John Lee on behalf of Mr. Brown, who is standing to my right.
How are you, Mr. Brown?
I'm doing good, man.
You can be seated. We gotta find your file. Grandma Kitty. You know what? What's gonna be a dummy file? She gonna find it.
Yeah, yeah. It's a little less. They said it was gonna be 50 miles an hour. I believe it was. Seen a lot of things just.
Well, and miracle of miracles, our Lions won, so.
Green Bay.
Just goes to show there's still hope in the world.
Second or third.
Yeah, they have not had many, that's for sure. Save yourself a lot of pain.
Yeah.
You have a copy of the citation, correct?
Yes, ma'am.
Yeah, I don't have one, but what is the offer on it?
He's going to plead his charge, driving unlicensed.
Okay, sounds good. She said no. Okay, so you've been charged in this matter with one count of no ops in possession. Also known as driving while license is not valid or improper, and you want to plead guilty to that, sir?
Yes, Your Honor.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Put your hand down. I have here an advice of rights and plea information sheet with today's date on it. Is that your signature at the bottom?
That's correct, Your Honor.
Would you read this document?
Yes, ma'am.
You understand the rights that are listed here?
Yes, Your Honor.
Do you have any questions about these rights?
No, Your Honor.
You understand that in order to plead guilty, you're gonna have to give up your right to a trial?
Yes.
You understand that also means that you're giving up your right to the presumption of innocence, meaning you're innocent until proven guilty. You're gonna give up the right to see, hear, or question any other witnesses the city intends to call. You're gonna give up your right to call your own witnesses or present evidence to bring a defense to this charge. And you're also going to give up your right to remain silent and not have silence be used against you. Lastly, you'll give up your right to have the city be required to prove each element of the charge being brought against you beyond a reasonable doubt. You understand that?
Yes, Your Honor.
Anybody threatening you to get you to waive your right and plead guilty?
No,
Has any promises been made to you if you waive your right and plead guilty?
no, Your Honor.
You're pleading guilty because you believe you're guilty?
Yes, Your Honor.
Do you have a factual basis? Oh, I'm sorry, ask the charge, how do you plead?
Guilty.
Thank you, no factual basis.
Mr. Brown, on or about July 7th, 2022, were you driving on Waverly Road near Sandhurst?
Yes,
Okay, and that's in the city of Lansing County, state of Michigan. And were you driving at that time without a valid or proper driver's license?
yes, sir.
Factual basis has been established, Brown.
Do you have a valid license now?
No, Your Honor.
Okay. Any further questions?
Nothing for the city, Your Honor.
If the court is satisfied with the factual basis, I'll accept your plea. And your plea to be made freely, voluntarily, and intelligently. And ask if your license was valid, because that I could have waived the fine, but because it's not, your fine is going to be $200. When can you make payment?
Towards the end of the month.
I know you're gonna make payment by December 2nd, okay?
Yes, Your Honor.
Do you have any questions?
No, ma'am.
Okay, you gotta make payment online, or you can come up in person, or you can mail check or money order.
I just do it up here. It makes it easy.
Sounds good, unless you have any other questions for me, you're all set.
All right, thank you.
Thank you. Okay, we have people in jail.
They're both rich and
You said what?
They were both rich and kind.
Great, we're gonna get them. Bench warrants been made. You have here?
Mr. Barber?
On the record of the matter, the people of the city of Lansing versus Jacob Barba, final number is 20-01809 on T. Council appearance.
Staples on behalf of the city of Lansing, Your Honor. Assistant Public Defender John Lee on behalf of Mr. Barber, who is sitting to my right.
How are you, Mr. Barber?
I'm doing good. How are you?
Doing pretty good. Today's the date that was set for a pretrial on a driving while license is suspended. How are we proceeding on this?
Mr. Barber would like to seek an adjournment. He would like to pursue getting his license reinstated, but is incarcerated until the 21st of November. So we're seeking a 60-day adjournment to give him an opportunity to do that.
Okay, so herein lies the concern. The case was issued in 2020, and Mr. Barber, you failed to appear 1, 2, 3 times already on this.
Honestly, I wasn't aware of the warrant until I got picked up on the charges in Clinton County.
Okay. And so,
I'm sorry for interrupting you, but I believe that I thought that I just had to pay the ticket, and then that would be that. It would be over with. But I guess that wasn't the case.
okay, what's your home address?
3392 West Taft Road, St. John's, Michigan, 48879.
Your phone number?
I've been locked up for a couple months and my phone's not on, but my mother's phone number is 517-898-1457.
Okay, I'm gonna adjourn this to give you an opportunity to get this taken care of. I do recognize that majority of your failure to appear is in the middle of the pandemic shutdown. I just want to ensure that you will return to court and that you'll keep up your end of the bargain as it relates to making efforts to obtain your license, okay?
Yes, ma'am.
January 10th at 9 a.m. January 10th at 9 a.m.
Thank you.
No problem. Do you have any questions for the court today?
No.
Okay, any additional matters for the record?
None for the city, Your Honor. None for the defense, Your Honor.
Okay, you're all set, sir.
West Taft Road, TAFT, St. John's, Michigan, 48879.
I'm gonna bench warrant Ms. Hunter. And this is James Little. We're on the record in the matters of the people of the city of Lansing versus James Anthony Little. I have file numbers 22-02469 and 02561. Council appearances.
Matt Staples on behalf of the city. Assistant Public Defender John Lee on behalf of Mr. Little, who is standing to my right.
How are you, Mr. Little? Okay. Today's date that was set for 2 pre-trials, both for open alcohol in public. Are we proceeding, counsel?
Mr. Little is prepared to plead guilty to 1 charge, and the defense has agreed to drop the 2nd charge.
Any particular charge that the city wants him to plead to?
Nope, they're the same charge, Your Honor, so it makes no difference to the city.
Okay, Mr. Little, you want to plead guilty to one count today of open alcohol in public?
Yes.
You raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Okay. You can put your hand down. Did you sign this document here?
Yes.
Do you understand the rights listed here? You read this document?
Yes.
Do you have any questions about these rights? Okay, you understand that in this matter, you have the right to proceed to a jury trial? You understand that at the time of jury trial, you have the right to the presumption of innocence. So you have the right to be presumed innocent until the city meets their burden of proving each element of the charge being brought against you beyond a reasonable doubt. You understand that? And you want to waive that right today? Okay, you also understand that that means you're going to be waiving your right to see, hear, or question any other witnesses the prosecution intends to call. You're also waiving the right to remain silent at trial and not have silence be used against you. You understand that? Okay, anybody threatening you to get you to waive your rights and plead guilty today? Can you speak up?
No way.
Any promises being made to you if you waive your rights and plead guilty?
Nope.
And you're pleading guilty today because you believe you're guilty?
Yes, I do.
As to file number 22-02561, the charge is open alcohol in public. How do you plead?
Guilty.
Have a factual basis, please.
Mr. Little, on or about September 23rd, 2022, were you on South Pennsylvania Avenue near East Miller Road?
Yes, I was.
And that's in the city of Lansing, the county of England, county of Ingham, state of Michigan. And at that time, did you have an open alcoholic beverage in a public park, contrary to?
Yes.
I believe a factual basis has been established.
Was you drinking, sir?
Yes, I was.
What were you drinking?
Beer.
Okay. Any questions from the city?
None from the city, Your Honor.
The court is satisfied with the factual basis. I will accept your plea if I your opinion made freely, voluntarily, and intelligently. Looks like he was arraigned on this matter back in September 29th to be exact. I'll credit him time served. You're all set. And then I did Benjamin Hunter, and I'll see if I'm sorry. I did. You said it's what confusion?
Yes, I don't know what
I don't know what this. Let me see what you're talking about. This new form.
yes. I'm like, where am I supposed to put the date? I know I'm not a notary. So let me know.
You don't
if
have
it's
to
in
do that.
there.
I don't think. Let me go all the way,
Okay.
Is that all you have, Mr. Lee?
Yes, ma'am.
Okay, thank you.
Thank you. Appreciate your time and your patience.
No problem. For the record in the matter, the people of the city of Lansing versus Johnny Charles Miggins III, file number 22-01820, OD, council appearance.
Matt Staples on behalf of the city of Lansing.
Matt Nagel on behalf of Mr. Miggins, who's present to my left now.
Thank you. I also have file number 22L2723591. Today was the date and the time set for a pre-trial and an evidentiary hearing on the PBT refusal. Are we ready to proceed?
We are, Your Honor.
Any preliminary matters?
Would state as a preliminary matter that it's the city's position that the defense has not met their burden for an evidentiary hearing. That they're to cite Franks v. Delaware, which has been confirmed by Michigan courts as well. To mandate an evidentiary hearing, the challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. The defense in this case has made no such showing nor provided any such exhibits to the court that would refute Officer Traverso's statements in his affidavit for the search warrant. And so we would ask that there be no evidentiary hearing based on the conclusions presented by the defense.
Thank you, Your Honor. Your Honor, we have cited the record that indicates that Officer Traverso was able to identify reasonable suspicion to investigate for an OWI, but according to his own notes and the record, that reasonable suspicion never gave rise to reasonable cause. This is based on the record. This is evidenced in the body cam video. It's evidenced in the police reports. And it is the purpose of this hearing to raise this issue on the record and challenge the reasonable cause supposition by Officer Traverso.
Do you want to respond to this?
My only response, Your Honor, would be that there was a wealth of probable cause, including, but not limited to, open intox in the vehicle within the reach of the driver, and the driver's appearance on top of the SFSTs. It's my understanding that the defense primarily challenging the SFSTs, and even if those were stricken as would be required, if they were found to be invalid by this court, there would still be enough probable cause on the face of the warrant to have acquired the blood draw.
May I respond to that, Your Honor?
Well, this is not an evidentiary hearing on the OWI, it's evidentiary hearing on the PBT refusal.
Well, the PBT refusal and the arrest, Your Honor. And if I may respond to
because it wasn't set that way. It's separate pretrial and operating intoxicated.
Oh, okay. It should be the evidentiary hearing is going to address both issues.
Okay, sounds good. So that's probably on our end and ours. I know you had previously filed a motion to suppress and thought it would be better addressed through an evidentiary hearing. You can respond.
Thank you, Your Honor. Just with respect to what the city attorney said, if the SFSTs were thrown out, all that's left is the odor of intoxicants from the vehicle and the open intox. If I could cite People v. Rizzo from 2000, that's 2243 Mich. App 151. At pages 154 to 55, the Michigan Court of Appeals has ruled that the odor of intoxicants alone is not reasonable cause. This was supported by a unanimous decision unreported in People v. Phillips from the Michigan Court of Appeals this past May 19th, and that's number 356255 at page 7, in which the Michigan Court of Appeals pointed out that the odor of alcohol and reckless driving still only amounts to reasonable suspicion, which would authorize the officer to investigate for actual OWI, which would come from subsequent roadside tests through the SFSTs, or something else that would indicate actual intoxication, which is absent on the record. So therefore, if the city attorney's position that even if the SFSTs were thrown out, there would still be probable cause
the factual record disputes that. There's still only reasonable suspicion, no probable cause to request either a PBT or to support an affidavit for an arrest.
May I respond?
Yes, please. stand
Sure.
and respond.
I would cite the actual affidavit of the warrant, which also includes an admission by Mr. Miggins that he had been previously drinking that night, an open intox and a small plastic cup that smelled of intoxicants, and his appearance of red and watery eyes also are on the record and were included in the affidavit for the search warrant. So it is more than just the presence of an open intoxicant. There is the defendant's presence, the smell of intoxicants, and an admission of drinking prior to having been pulled over, Your Honor.
And is it the city's position that all of those things were observed by the officer prior to the PBT?
That is correct, Your Honor.
That would still only support reasonable suspicion, Your Honor. There is no behavior of intoxication. And not to mention the affidavit is actually, and now we're getting into the evidence that we intended to call out during the cross-examination.
Let me have you repeat. We have bloodshot, watery eyes.
Bloodshot, watery eyes, an open bottle of tequila that was about 1/5 still full, small plastic cup smelling of intoxicants in the center console, the underlying reason for the traffic stop, which was running a red light, and then also red watery eyes and an admission to drinking prior to the stop.
So actually, according to the body cam footage recorded by Officer Traverso, Mr. Miggins had admitted to drinking earlier that day, not that night.
Okay, but we're trying to understand what's the basis of the evidentiary here.
The basis of the evidentiary hearing is basically what we're discussing, Your Honor. That this is that Officer Traverso incorrectly filled out the affidavit. Mr. Miggins had stated that he was drinking earlier that day, not that night. That everything reported only amounts to reasonable suspicion. It does not amount to reasonable cause. That bloodshot eyes gives officers, the way they're trained, according to the National Highway Transportation and Safety Administration, that gives rise to reasonable suspicion to investigate for OWI. The clues for establishing whether or not somebody might be under the influence does not include red bloodshot eyes. The clues, 2 of which are noted in the affidavit, but the affidavit only notes 2 in order for there to give rise to reasonable cause that the person might be intoxicated. The National Highway Transportation and Safety Administration teaches that there must be a minimum of 4, but there are only 2 listed in the police report. There are only 2 listed on the affidavit.
As to the SFSTs, is that what you're referencing?
As to the HGN, specifically to the SFSTs. Furthermore, Your Honor, the body cam footage is going to indicate that Officer Traverso improperly wrote out the clues that transpired during the walk-in turn. That Mr. Miggins started too soon, when in fact, when Mr. Miggins supposedly started too soon, he had not been instructed to wait until he was done with the instructions.
Oh, sounds good. The motion is denied. You can proceed with the evidentiary.
Thank you, Your Honor.
Do you have a preliminary matters?
Only that I spoke to the city attorney prior to the start. We have stipulated to the body cam footage for the record. I have Officer Traverso's body cam footage and Officer Lopez's body cam footage. Officer Lopez's body cam footage is helpful for us because we can see both Officer Traverso and Mr. Miggins during the conduct of the SFSTs.
Sounds good. So let's step to the body cam for both Officer Lopez and Traverso. Any other preliminary matters?
Nothing further from the past.
Okay, you can proceed.
Thank you, Your Honor. Mr. Miggins calls Officer Traverso.
Officer Traverso. You solemnly swear or affirm the testimony you're going to give is the truth under the penalty of perjury.
Yes, ma'am.
You can have a seat, sir. Please state your first and last name and spell both of them.
My name is Joseph Traverso, Jospeth, PRA, he is convicted, ERS.
You can proceed, counsel.
Thank you, Your Honor. Officer Traverso, can you tell us for the record what your current occupation is?
My current occupation is a police officer at the city of Lansing,
And so for which department do you work for then?
Lansing Police Department,
Lansing Police Department. How long have you worked for Lansing Police Department?
just under 2 years.
2 years. And as part of your employment, have you been trained in DUI detection?
Yes, it's part of every academy, I believe. It was part of the academy training.
And that DUI detection, are you trained according to standards that were published by the National Highway Transportation and Safety Administration?
I'm not sure, whatever they covered.
Okay. Did you? I apologize, I only have a electronic version of it, but did you receive a textbook that covered something similar to that?
No.
No?
Can you identify for the record what you're showing him?
So I'm showing the witness, the participant manual for DWI detection and standardized field sobriety testing, SFST.
I don't believe so. We had a course that was taught by an instructor that could have done the PowerPoint.
Could have been in the PowerPoints.
It could have.
Okay, so in your course of instruction, you were taught that when investigating for DWI, there are 3 phases, correct?
Sure. Yeah. I mean, there are more than that can be used, but.
So the 3 overall
Usually.
phases are vehicle in motion, personal contact, and pre-arrest screening. That sound familiar?
Sure. It's been a little while since the academy, those terms, but yeah, that does sound familiar.
So I just want to be clear. Are you qualified to perform SFSTs?
Yes.
Okay.
Yes, sir.
And are you qualified because you received that training?
Yes, sir.
Okay. And are you qualified prior to that training because you tested for your knowledge?
Yes.
Okay. And then you passed with the knowledge of how to conduct a DWI detection, correct?
Yes.
Okay. So to your knowledge, the 3 phases of DWI detection, it begins with vehicle in motion, correct? Personal contact?
Yes.
And then the 3rd phase is the pre-arrest screening, correct?
Yes.
Now, the first phase, vehicle in motion, it begins when you first notice the vehicle, correct?
Objection, Your Honor. I mean, he's asked and answered. I mean, these have been repeated several times now.
As this question that he just asked?
As to these 3 steps of the investigation, I mean, they're repetitive question.
I don't know that we've gotten a clear answer, so the objection's overruled.
Thank you, Your Honor. So once again, when in the first phase begins when you first see the vehicle, correct?
Yes.
And you decide whether or not there's reasonable suspicion to stop the vehicle based on whatever you do, correct? So at that point, you have 3 determinations. You can decide to stop the vehicle if there's reasonable suspicion to do so, correct?
Yeah.
You can also choose to continue to observe, correct?
Yes.
Or you can just disregard the vehicle, situation dependent, correct?
Yes.
Now, in the case of Mr. Miggins, you observed him make a right turn while disregarding a red light, correct?
Yes.
So this disregard of the red light while making a right turn, this was your reasonable suspicion to support the actual traffic stop, correct?
Yes.
Now, at this phase, once you've noticed the vehicle, you're looking for additional signs of impairment, right?
Yes.
So, and these can manifest in a number of different ways, like slowed reactions, correct? So if he was slow to pull over to the side of the road, once you've indicated we're going to initiate a stop, that would be a clue, correct?
Yes.
Impaired judgment evidenced by willingness to take risks. So like if he were to speed up or something, correct?
Objection, Your Honor. Relevance. I mean, we've already established why the vehicle was pulled over.
This is all part of the DWI investigation. These are things that could support reasonable cause. If noticed by the officer, the point of this line of questioning is to indicate that the officer did not see any clues of intoxication at this phase.
I'll allow it. Objections overruled.
But that was a confusing way I asked the question. So let's say willingness to take risks is another factor that may give rise to suspicion of OWI, right? Sure. It's like maybe if he were to speed off, that would be a foolish thing to do, right? A risky thing to do. Yeah. Okay. Anything that might indicate to you that maybe his vision is impaired would be another clue. I'm sorry.
Yes.
And any signs that you can view while he's driving the vehicle that might indicate poor coordination, that'd be another clue, correct?
Yes.
Now, when you activated your lights to initiate the stop, Mr. Miggins immediately made a left turn into a driveway, right?
He was already making that turn into the driveway before I activated.
Okay, and so he pulled into the driveway, but while he was pulling into the driveway, you didn't notice any of these clues, did you?
No.
I think you had to ask him to move forward a little bit because you were right behind him, do you recall?
Yes.
And was there any hesitation with him moving forward to give you more space to pull in?
Didn't see it.
Also, at the time that you noticed the illegal right turn, the time of night was give or take about 10:20 p.m., correct?
Can you speak up, please?
I don't recall.
It was late at night, though, to your
Yes,
recollection.
it was dark out.
So not taking away from the fact that there was a red light and he did turn illegally at that red light, there was no other traffic coming before he made that right turn, correct?
I don't recall how busy the street was.
He didn't have to swerve around any cars, did he? You don't recall any vehicles coming that had to move around him?
No.
Okay. So other than the fact that he was required to stop before making that right turn, there was no indication by making that turn that he was doing anything that might indicate that he was impaired, correct?
Objection, speculation, Your Honor.
Objection sustained.
Based on, okay, well, I'll rephrase. He wasn't taking any unnecessary risks with respect to his own personal safety or the safety of others when he made that right turn, correct?
Objection, relevance, legal conclusion.
I'm going to sustain the objection. I think, first of all, because you're actually asking questions as if it's a cross exam. If you probably ask an open-ended question, he probably could get the information you're looking for.
I'm sorry.
You're essentially cross-examining him. So and you're asking him in this question to provide information that causes for speculation and causes him to have to give a legal conclusion. So I'm going to sustain the objection, but there is I believe, a way for you to formulate the question and get the information I think you're trying to get.
Thank you. I understand. So when he made the right turn, did you see anything to give you to indicate to you that he may have been impaired at that time?
Running a red light is very synonymous with drunk driving.
Was there anything in addition to the illegal turn?
Besides for running a red light?
Yes. At that phase. Have you ever pulled over somebody for making an illegal right turn who was not impaired?
No. For running a red light?
Yes.
Yes, I have pulled over people who are not.
So when you see the vehicle in motion, there are 4 categories of driving behaviors that you're also trained to look for, correct?
Yes.
Such as problems with maintaining lanes, right?
Sure.
Speed and braking problems, right?
Sure.
Say vigilance problems, being able to pay attention to things happening around him, correct?
Yes.
And then also something that would indicate a problem with making judgments in the drive, correct?
Yes.
Prior to pulling over, initiating this traffic stop, other than seeing the red light, you didn't indicate any problems with any of these 4 categories in your police report.
Objection, Your Honor. Asked and answered. We've really been laboring this
Objection
point.
sustained.
Did you notice any problems with Mr. Megan maintaining his lane of travel?
Objection again, Your Honor, asked and answered. We've pretty much established everything to the point of the traffic stop.
Yeah, I think he answered that he didn't see anything else.
Okay, so we'll move on then to the personal contact. So you are taught to approach and observe and interview the driver while they're still in the vehicle, correct?
Correct.
And you're looking for evidence of impairment when you're talking to the person?
Yeah.
Okay. And during this phase, you are looking for using your three senses, correct? Sight, hearing, and smell while making personal contact with the driver?
Yeah.
So the sight clues that you're taught to look for include bloodshot eyes, right?
Yes.
Soiled clothing, correct?
Yeah.
Fumbling fingers.
Yeah.
So alcohol containers. Drugs and drug paraphernalia.
Yes.
Bruises, bumps, or scratches, right?
I don't recall that being part of it, but it's before.
In this case, that you did see bloodshot eyes and you did see some alcohol containers.
Yes.
But you didn't see any fumbling around looking for his driver's license, his registration, anything like that?
Not that I recall.
So the hearing clues, you're looking for things like slurred speech, right?
Yes.
You're looking for any admission of drinking, right?
Yes.
And in this case, Mr. Miggins did admit to drinking earlier that day, correct?
He did admit to drinking.
You're looking for inconsistent responses, right?
Yes.
Any unusual statements that he's making that don't are not quite relevant to any questions you're asking, right?
Yeah.
You're looking for abusive language, right?
Yeah.
Anything else that might indicate intoxication based on what you're hearing, right?
Yeah.
In your police report, other than the admission that he was drinking earlier that day, you did not indicate any of these other factors, did you?
I believe in my police report, I did reference that there were open intoxicants. I smelled intoxicants in the vehicle, and there was clear plastic cups that smelled of intoxicants as well.
Your Honor, objection moving forward, referring to a document not in evidence by referring to the police report.
I don't think the question called for the police report.
The question stated, Your Honor, in your police report, did you state the following?
That was your question?
I think it was. I think what I meant to ask was in your affidavit, you did not indicate any of these other.
I'm sorry, can you repeat the question?
In your affidavit for a warrant, you did not indicate any of these other clues, correct?
I believe I indicated the smell of.
Objection, Your Honor, the warrant and the affidavit are not in the record.
Objection sustained.
Okay, so let's back up then. On the night of July 9th, 2022, you conducted a traffic stop of Mr. Mittens, correct?
Correct.
You investigated for OWI?
Correct.
During that investigation, you had asked for his consent, whether you would consent to a chemical test?
Yes.
And he declined?
Yes.
And as a result of that him declining, you submitted an affidavit for a blood draw, correct?
Yes.
And in that affidavit, you indicated the results of your of what you indicated the results of what you report to be the results of your investigation, correct?
Yeah.
Mayor Pro Tem.
You may.
So I'm showing Officer Traverso a copy of the affidavit that the defense has in our records. Does this look familiar to you?
Yeah.
Does this appear to be the affidavit that you had submitted on the night of July 9th?
Yeah.
Your Honor, I'd like to submit the affidavit as Defense Exhibit A.
Any objection?
None, Your Honor.
You had it marked.
I need to have it.
She could mark it for you.
Okay, so if I can return to what I was, my previous question then, and just to help you out, we were talking about hearing clues. So you were indicating some other clues that you saw, and I will get to that. But for right now, we're just talking about hearing clues. And in your affidavit for warrants, you did indicate that he had been drinking earlier that day, correct?
Yes, I indicated that it was been drinking.
But you did not indicate any of these other clues, correct?
If we're just talking about hearing clues.
So then let's talk about the smelling clues. So the smelling clues include alcoholic beverages, correct?
Yeah.
Marijuana. Smell of marijuana. The smell of anything that smells like they're trying to cover up an odor, correct?
Yes.
And any other unusual odors that may give you reason to suspect that the person is impaired, right?
Yes.
And you did indicate that you could smell the odor of alcoholic beverages, correct?
Yes.
And you did indicate this to Mr. Miggins during your initial personal contact, right?
I believe so.
And when you mentioned that you could see the alcoholic beverages there, the passengers in the vehicle, you know what, take that back. Now, based on your observations of during the traffic stop, you decided that you were going to investigate for no DUI and asked Mr. Miggins to exit the vehicle, correct?
Yes.
And then we had to pause that investigation, correct?
Yes.
Because there was a gun in the door, and then you had to investigate for your own personal safety to make sure that there was nothing else that might be a threat or a risk of a threat to you and your fellow officers you were on scene at the time, right?
There was an unsecured threat.
But then eventually we did return in order to start the investigation, right?
Continue, yes.
To continue the investigation. And one of the first tests that you performed was the horizontal gaze nystagmus test, correct?
Correct.
What is nystagmus?
Nystagmus is the movement in the eyes, usually affected by treatment.
Can you be more specific?
No. I could.
So I asked you what is nystagmus, and your answer is it's movement in the eyes caused by alcohol.
Yeah.
Can you describe that, that movement in the eyes?
I mean, uncontrollable, it's shaky. And I don't know how else to answer.
Well, do you know what you're looking for when you're
Yes.
conducting an organ? Okay, can you explain to us what you're looking for?
I believe I just said shakiness in the eyes. That's uncontrollable.
So your definition of nystagmus is uncontrollable shakiness in the eyes.
Sure. Yes.
Are you positive?
That's what I'm saying.
So for a horizontal gaze nystagmus test, there are 10 performance steps, correct?
Sure. Yeah.
So the first step is that you are required to ask the subject whether or not he wears eyeglasses, right?
Yeah.
Next, you give verbal instructions on how the subject is to position themselves during the test and what the test will look like, right?
Yeah.
Then you're supposed to position a stimulus away from the driver's face while conducting the test, correct?
Yes.
Objection testifying, Your Honor.
Yeah, you let him, why don't you ask him how he performed it versus this cross-examination format that you're giving him?
I believe I'm permitted leading questions, Your Honor, since the witness is under Michigan Rules of Evidence 611. The witness is a party who is identified with, is a witness who identifies with an adverse party. Under that court rule, leading questions are permitted.
Correct, but you are given a lot of testimony in your questions.
Well, it also seems helpful in this case, Your Honor, because the officer doesn't seem to remember his training very well.
Well, who is it helpful to?
I'm sorry, Your Honor?
Yeah, who is it helpful to then? You're trying to help him is what you're saying?
I'm trying to help him remember these steps, yes, Your Honor.
Do you want to respond to his response?
I guess if he wants to lay out the steps for my witness, that's fine with me.
So you're also supposed to indicate, or you're also supposed to note whether or not there's equal pupil size and any resting nystagmus, correct?
Yes.
Then as far as the actual test, the stimulus starts from the center, correct?
Yes.
And you move from the center of the driver to the far, from center to far right, correct?
I mean, I don't believe it matters which side you start with in the actual test.
For this particular portion, I would prefer you ask him how he performed, how he's supposed to perform this test.
Can you describe how you would perform a horizontal gaze nystagmus test?
Start to finish.
Yes, please.
Usually I do have a sheet that I talk to the prosecutor about. I don't know. I usually read it off for every single rule that I investigate. I don't know if that's okay for you to look at and reference.
So you're saying that you don't know off the top of your head, but you do have a guide that you use, what you're saying?
You have a guide that.
Oh, okay. That's good.
If Your Honor, I could lay foundation and have it admitted into evidence.
That's fine.
Yeah. Officer Traverso, do you recognize this document?
Yes,
And can you describe to me what that document is?
it's an SFST scoring sheet.
And is this something issued to all road officers in the Lansing Police Department?
No.
Who is it issued to?
It was actually given to me by a colleague who used it for his
But is it
OUI
is it
investigation.
common for officers in the Lansing Police Department to carry this or something very much like it?
Yes,
Okay, and in the course of your work as a police officer, do you often use this document when performing SFSTs?
yes.
Foundation established, Your Honor.
Specifically for me, thank you. Any objection to him identifying or using that to describe what he uses to perform the SSFTs?
May I ask just a couple of what your questions about the,
Absolutely.
so you testified that this is not something that's issued to you, correct?
Not like formally. They don't formally give it to us and say, you must use this for every OWI you investigate. It was given to me by a colleague. I'm not sure what he got.
It was given to you by a colleague who created it. You did not create this.
I did not create that.
And do you know what your colleague used to reference when he was creating this?
I do not.
So to the best of your knowledge, whatever is in this document, this is not in accordance necessarily with the administrative rules, at least as far as you know, correct?
I don't know how to answer that because based on my training, I do have a lot of that coincides with my training.
But you don't know whether or not this coincides with the administrative rules?
Verbatim, no.
Do you know whether or not this coincides with the training manual you were issued when you were in basic training?
It does coincide with the stuff that we were taught when we were training.
Did you, and you know this because you checked the knowledge against the book?
I don't understand. I went through the training and I looked at the sheet.
So if there's anything missing on this, or if there's anything inaccurate on this, you wouldn't know off the top of your head whether or not it was correct or incorrect.
I'm not sure what you're asking. I'm sorry.
I think that's.
Okay, thank you.
So we marked as plaintiff's exhibit A, Your Honor.
I think that's a-
People's, sorry.
People's, we have a specific one, people one.
Oh, people one. Okay. Trying to approach. Person. So Officer Traverso, why don't you go ahead and explain to us how you run a horizontal business status test?
So usually I'll have them outside of the car. I find a flat, mostly even surface I can conduct testing in front of. I ask them, are you wearing contacts or glasses? I tell them, we're gonna check your eyes. Stand with your feet together, hands by your side. Follow the stimulus with your eyes. Do not move your head. Focus on the stimulus until I tell you to stop. And usually I'll take out my pen and I'll show them and I'll say, hey, this is gonna be the stimulus. And I hold it out in front of them and I conduct one test, which is checking their eyes at first for any resting nystagmus, pupil size. And then I just go through my list and check for lack of smooth pursuit. Check for distinct and sustained nystagmus. Onset nystagmus prior to 45 degrees. And then vertical nystagmus.
Okay, so do you remember being taught that the stimulus is supposed to be held out at a certain distance from?
Yes.
And what is that distance?
12 to 15 inches.
And in relation to the driver's eyes, how high is that stimulus supposed to be?
How high is it supposed to be?
Correct.
Even with their eyes?
Even with your eyes. You don't remember being taught that it should be slightly above eye level?
All right. Okay.
And then when you pass, when the stimulus passes from, say, one side to the next, at what rate of speed is that stimulus supposed to pass from one eye to the next?
For lack of smooth pursuit is approximately 2 seconds out and 2 seconds up.
2 seconds from maximum deviation to maximum deviation, correct?
No. That starting point in the middle, out, back. 2 seconds, 2 seconds.
And do you recall how long you're supposed to hold that stimulus at maximum deviation before continuing?
4 seconds,
And did you do that in this case?
I believe so.
So at this time, Your Honor, the city attorney and the defense stipulated to the body cam footage of Officer Lopez. Make sure I'm holding the right one. I'd like to admit this as defense exhibit B.
It's admitted by stipulation. You want to tag your,
Just gonna put it on the outside.
oh, okay. How does it?
So yes, I think it opens like that.
Okay,
So if
so
we
I'll
wanna-
put it around it.
Yeah, that's what I was thinking.
This was Officer Lopez's video, correct?
Yes, Your Honor. Is there a HDMI cable I can use for the screen?
That way, or you could do it that way or connect it here.
I'll connect it there. I still prefer hard lines. The remote stuff, something always goes wrong. Okay, so Officer Traverso, I've got loaded here Officer Lopez's body cam footage from that night. Does this setup look pretty familiar to you?
Yes.
And who's that figure right there? Just right of center.
That would be me.
That's you. Okay. All right. So I'm going to play. I think we're queued up to where the horizontal gaze and stagnance test begins. Attention.
Yes, sir. Yes, sir.
Okay, so that document in your hand, that's the guide that you produced earlier?
That is this one. Yep.
Okay, man. So first off, are you wearing contacts or glasses? You said you were wearing contacts, right? Okay. Do you have any?
Okay, so step one, are you wearing eyeglasses or contacts? And he answered in the affirmative, correct?
Mm-hmm.
Is that a yes?
Yes. Sorry.
Any other eye problems? Just contacts. Okay. Any diabetes or anything like that? No. Okay. Okay. I'm gonna check your eyes. Okay, so stand with your feet together, hands by your side. Okay. This is gonna be the stimulus. Okay. Sorry. Tip of my pen is gonna be the stimulus. Okay. So you're gonna focus on that. All right, and you're gonna follow it with your eyes, but do not move your head. That's the important part. Okay.
Approximately how far away from his face is that stimulus?
Approximately. I couldn't tell you by looking at this video. but
How far away is the stimulus supposed to be from the?
12 to 15 inches.
And how do you determine that you've held the stimulus 12 to 15 inches from the private space?
I estimate 12 to 15 inches.
So it could be closer to 12 or 15 inches and you wouldn't know.
Objection, speculation.
Well, yes, it could be, and you wouldn't know is what he's saying. So that doesn't cause for speculation. He already actually answered that, said he didn't know how far it was, so you can answer it again, I guess.
I guess
And so on this night,
I
based
wouldn't
on
know
this,
exactly how far it is.
okay, but on this night, according to this video, can you tell how far away from his face that stimulus is positioned?
I can't give you an exact number. No.
Okay, so that's approximately 2 seconds from center to maximum deviation on the left side, correct?
Correct.
Okay, and then for how long is that stimulus supposed to be held on the left side?
Well, it depends on what you're checking. So right now I'm checking for equal tracking. So it's 2 seconds out, 2 seconds in. You'll see later in the video, I do a separate check for maximum mistake.
You don't remember being told that you're being taught that 2 seconds to the left, and then as you testified earlier, you hold it for 4 seconds?
You hold it for 4 seconds to check for misstatements at maximum deviation.
On each pass, correct?
No, you don't have to do it that way.
When you were in the academy, they taught you that this is how it's supposed to be done, but you don't have to do it that way. Is that what you're testifying?
Either way, you're checking for maximum. You're doing the test. It's just not synonymous or consecutive.
I'm lost at this point.
Yeah, Your Honor, this is argumentative. The witness stated that there's two different things he's looking for. I don't think that brother counsel's questions are acknowledging that.
What was the last question? Because I got so lost in the response.
Well, Your Honor, we're going through the horizontal gaze nystagmus test, and prior to this, when Officer Traverso was reading from his guide, the testimony is that officers are taught these 10 steps for the horizontal gaze nystagmus test, and that part of those steps is that the stimulus is supposed to transfer from center position to maximum deviation on the other side, tracking for 2 seconds, and then held for 4 seconds. Nowhere in the instruction are officers taught that they can change it up with respect to.
Well, I
what
think
they're
that's
looking
where
for.
your argument is, but you were asking him if he can change it up, correct?
I did not actually.
Okay, well, we can't make argument right now.
Well,
you can ask them if they were taught that.
Well, understood, Your Honor. I think that's my point that I'm getting at. So earlier when you testified that what you're taught is 2 seconds to maximum deviation, then you hold for 4 seconds. That's what you testified to, correct?
I believe I testified.
I'm sorry, are they talking to the witness? What's
No,
happening here?
I'm saying that this is asked and answered, Your Honor. Objection.
Well, I need clarification
Okay.
now.
Okay.
So.
And I want to rephrase the question.
Thank you.
Yes. So this is what you testified to previously, correct?
Okay, I believe what I was testifying to was at maximum, when you are checking for maximum deviations, you have to hold it there for 4 seconds. And that is what I said yes to.
Were you taught, do you remember being taught that you performed this test 3 times, each time looking for one of those 3 clues? Do you remember being taught that?
Yes.
And were you taught then that you can change up the test according to what you were looking for?
We were not specifically told you can change it.
Okay, you previously stated before there was an objection that you didn't have to do it a certain way. What are you referencing that you don't have to do a certain way?
I've always learned from other people that have done it that as long as I can check off these boxes. So the way I do it is I like to check for smooth pursuit. And then a separate test would be checking for maximum deviation.
Okay.
And that's when I hold my pen out at 4 for 4 seconds.
Does that clarify what you were asking?
I guess.
I think that does, Your Honor, but we can save time if you would just say on the record that that is not what you were taught. at the
Objection, Your
district.
Honor.
You're asking him,
That's not what you were taught at the academy, correct?
the objection is what?
Testifying, badgering,
Well, he's asking,
argumentative.
he needs to answer whether or not he was taught that. That's a valid question.
I believe I already answered that. No.
Can-
That's
you were
not
not
the
taught
way
that.
we were taught.
Then we can move past the HGM. Thank you, Officer. Peters. So after the HGM, here, I'll just take that off for now and come back. After the HGN, you moved on to the walk and turn, correct?
Correct.
Now, the walk and turn has two phases, right?
The instruction phase and performance phase.
Perfect. We are on the same page. So during the instruction phase, the driver is instructed to stand a certain way, correct?
Correct.
Can you tell us for the record what that is?
Place your left. What I tell people usually is to imagine that there's a straight line in front of you, and then I tell them place your left foot on that line, real or imaginary, and put your right heel against the toe of your left foot. Place your arms by your side and maintain this position, and do not do anything until I tell you to start. You understand?
Can you demonstrate that for us?
So, there was an imaginary line in front of me. I'd say put your left foot on that line and put your right heel against the toe of your left foot. So they put their left foot on that line and then the right heel on their foot and arms by their side.
And they are supposed to stand in this position while you give the remaining instructions, correct?
Yeah.
Thank you very much. Now, during the instruction phase, you are taught to look for two clues, right?
Can't balance during instruction.
So just so that that's clear on the record, you can't balance during instructions and whether or not the driver starts too soon. Those are the two?
Sure.
Okay. Now, during the second stage, the walking stage, you are taught to look for any number of 8 clues, correct?
Yes.
Okay, and those steps and those clues includes whether or not they start too soon, whether or not they stop while walking, correct?
Yes.
Whether or not the driver touches heel to toe, whether or not he steps off line, whether he uses his arms for balance,
Yeah.
Whether he makes an improper turn,
Yeah.
and whether there's an incorrect number of steps.
Yes.
And then you are taught that 2 or more clues during the walk and turn tests is a sign of intoxication, correct?
Yes.
I'm going to queue up the SFST again. So once again, we're in the same defense exhibit. That is you on the screen there.
Yes.
Okay, but it's gonna be 9 steps. Heel to, all right? So you're gonna place your left. You're gonna imagine there's a straight line. Alrighty. Our next test is gonna be the walk and turn, okay? So what you're gonna do is you're gonna imagine there's a straight line running right in front of you, okay?
Okay, so this is the instruction phase. Correct?
Yes.
And it looks like you know this well enough, you're not reading it from the card, correct?
Yes, I try not to stare at the card.
Okay. Um,
Test is gonna be the walk and turn, okay? So what you're gonna do is you're gonna imagine there's a straight line running right in front of you, okay? And it's gonna continue all the way down. I'll explain that part, okay? But it's gonna be 9 steps, heel, all right? So you're gonna place your left foot on that imaginary line, okay? And then you're gonna put your right heel against the toe of your left foot. So you can do that now. Okay. Right, oh, no.
okay, so there he started a little quick, correct?
Yes.
And he did so after you said you can do that now, right?
As talking about putting his right heel to his left toe.
But at no point in those instructions did you tell him to wait until you told him to begin, did you?
I don't believe I could get to that point.
Okay, but and then if you hadn't told him not to start too soon, then this would not be. Then this would.
Objection, testifying, Your Honor.
Well, I don't know what the question was. If
If
you
you
didn't,
hadn't told him to start too soon,
then this wouldn't been, this would
Right.
stop, so I don't know what the question is. Let
I
him
mean-
ask the question first, and then I can tell you if he's gonna answer it or not.
I'll rephrase the question.
Okay.
Had you told him to wait to start until you told him to?
Well, the question is, had you told him to wait and start?
Had you instructed him
Okay.
not to start until instructed to?
At this point,
Yes.
No, you're just gonna, but you're just gonna stay there right now, okay? This is the instruction board.
Okay, so now he's informed that he's gonna stay there during the instruction phase, correct?
yes,
Now, Mr. Miggins has been instructed by you.
yes.
Portion of it, you understand?
Still working on.
So you're gonna put your left foot on that imaginary line, right heel to your left toe, okay? And you're gonna stay there, and you're gonna put your arms by your side and maintain this position until I tell you to start. Do you understand? Okay. So when I tell you to start, you're gonna take 9 steps, touching heel to toe along the line, and 9 steps touching heel to toe back down. On the 9th step, keep your front foot on the line and turn by taking several small steps with the other foot. Watch your foot while you walk. Count your steps out loud and keep your arms by your side. Once you begin to walk, do not stop until the test is complete. Do you understand? Okay. So I'm going to show you what I mean when I'm talking about this stuff. Okay? Yeah. No. Keep like that. Okay.
So he had asked, do you want me to do it while you say it? And he sort of adjusted his weight, correct?
Sure.
And then you told him, no, go back to how you were standing?
This is still the instructions portion. Okay. So you're gonna start and it could go 7, 8, 9. Okay. And then you're gonna take a series of small steps, pivoting on your left foot until you're facing the other way. Then you're gonna start right back over. Okay. 1, 2, 3, and so forth, back until you get to 9. And then the test is going to be complete, okay? All right, you may start.
Okay, so during the instruction phase, he was paying attention, correct?
Seems so.
He wasn't using his arms to maintain balance?
No.
He wasn't swaying?
No.
For the marathon, 2818 East KZ, get a hot trip.
Two, 3, 4, 5, 6, 7, 8, 9,
Okay, so during that, he wasn't using his arms to maintain balance, correct? He didn't step off the line.
Can you speak up, please?
I think that's arguable. I don't recall, but it seems like you will pigeon-footed.
You didn't put in your affidavit that he'd stepped off the line, did you?
I guess I didn't observe it then.
He didn't use his arms for balance. I think I already asked that. He didn't stop while walking.
Nope.
His turn was made according to the instructions.
Yes.
He used the proper number of steps.
Yes.
Now, you indicated in the affidavit that he missed a number of steps. From that video, could you tell which steps he missed?
Not from that video.
Can you describe what you mean by missed the steps?
He missed heel to toe.
And by how far? By how far did he miss the heel to toe?
He missed heel to toe. I couldn't put an approximate number of inches on it.
Do you remember being taught during basic training that you are permitted up to a ½ inch of separation between heel and toe in order for it to count as a completed step?
I don't recall.
And that's not on your handy guide there either, is it?
No.
After this, you moved on to the one leg stand, correct?
Yes.
And in your affidavit and otherwise, you indicated that there were no clues with the one-legged stand, correct?
I believe so.
Now, one of the reasons you're supposed to ask whether or not the driver is wearing eyeglasses or contact lenses is because the presence could cause for a distortion in the size of the eyes, right?
Yes.
Did you indicate in the affidavit whether or not he was wearing contact lenses?
No.
Thank you, Officer. No further questions.
Ross. Well, if you want to, I guess, redirect your witness.
Officer Traverso, you've done a number of OUILs, pulled people over for drunk driving. This is not the first time, hasn't been the last, correct?
Yes. Correct.
And when filling out the affidavit for a search warrant, is noting contact or glasses wearing a regular practice of the Lansing Police Department as far as you're aware?
Not as far as I'm.
Okay, and when you pulled Mr. Miggins over for running the red light, there was a bottle of liquor within reach of the defendant that had signs of having been drank from. It was not a full capped bottle of liquor, correct?
Correct.
And there was also a clear plastic cup in the center console that you described as smelling of intoxicants.
Correct.
And that the defendant also smelled of intoxicants.
Sorry. Correct.
And that defendant had eyes that were red and watery.
Correct.
Okay, you also testified that defendant admitted that he had been drinking approximately 3 hours prior to the traffic stop and had, quote, 2 shots of liquor.
Correct.
Nothing further, Your Honor.
Anything else?
Nothing further.
Okay, this officer may be excused from the stand. Thank you.
Thank you.
Any additional officer witnesses or witnesses?
No further witnesses, Your Honor.
Okay, that's the only exhibit you were admitting?
The affidavit and the body cam footage, Your Honor.
I thought you stipulated to 2 body cams, or just one that you're admitting?
We had stipulated in case I needed to use it. I didn't determine I needed to use it.
Is the city going to be admitting any evidence or calling witnesses today?
Not other than the sheet in the possession of Officer Traverso, Your Honor.
Okay, thank you. You can make your argument.
Thank you, Your Honor. Prior to the beginning of the evidentiary hearing, I did mention this already. There are two case law that identify what gives rise to reasonable suspicion and what gives rise to reasonable cause. What the record has shown here today is that Officer Traverso understandably had plenty of reasonable suspicion to investigate for an OWI. However, that investigation failed to give rise to reasonable cause, and so therefore he did not have reasonable cause to request Mr. Miggins submit to a PBT, nor did he have reasonable cause to request that to take him into custody for suspicion of OWI, let alone request an affidavit for a warrant to for a blood draw at that time. Officers are taught that a standard. That standard is put forth by the National Highway Transportation and Safety Administration. The test for whether or not HGN test should be admitted is whether or not that HGN test was performed properly, and is not a question for the jury. And in the motion, we cited People v. Berger, 217, Mish App, page 213, specifically 217 through 218. This is a case from 1996. And this has to do with whether or not what the standards are for admitting the HGN. In this case, Officer Traverso admitted that he deviated from the standards what he was taught at the academy, albeit he testified that he did this because he was told some other things by other officers. But be that as it may, it does not meet the doctrine as it was taught at the police academy when he was originally taught this. And he admitted on the stand that at no point during his initial training was he taught that he could deviate from the 10 steps based on what he was looking for. If he were permitted to do that, it would be impossible for defense counsel to review these HGN tests in order to determine whether or not the officers had conducted it properly. The best thing for an officer to do is to perform the test as taught each time, regardless of what he was looking for on each pass, in order so that the officer can support the state can support the burden of proof that it was done properly. Since the HGN was performed improperly, the HGN should not be admitted as evidence to support reasonable cause. Even if the court were to disagree, the affidavit only states that that there were two clues as taught by the National Highway Traffic and Safety Administration, when the officers are taught to look for 4 clues. Next, the officer noted in his affidavit that Mr. Miggins started too soon during the walk-in turn. The video shows that Mr. Miggins, once instructed, did not start too soon. He followed instructions, was able to maintain balance. He stayed on the line. From what we can view on the video footage, managed to hit every step heel to toe. But even if the court were to agree with the Officer Traverso that a step or 2 was missed, there's only 1 clue of intoxication during that test. When officers are taught to look for 2 clues, were 2 clues present, then that would support an argument for reasonable cause. The next test that was given was a 1-leg stand. Officer Traverso noted that there were no clues. The investigation, again, began with plenty of reasonable suspicion, but what we're left with at the end of the day is that reasonable suspicion never gave rise to reasonable cause. Reasonable cause and reasonable suspicion are certainly the lowest standards that we talk about. But again, the Michigan Court of Appeals has ruled on this to help us. And the courts have ruled that odors of intoxicants is not reasonable cause, it is reasonable suspicion. And certainly Officer Traverso was justified to investigate based on the presence and odor of alcohol. The odor of alcohol and reckless driving was ruled as reasonable suspicion. Again, these are actions that give an officer reason to think that maybe I should investigate, but there needs to be some other indication from the driver, some action, whether he stumbled out of the car, slurring his speech, is fumbling with his license, is swaying when he's supposed to be standing still during the walk and turn, misses certain steps. He answers the question illegibly or inconsistently. When in the video, we can see that Mr. Miggins was very lucid. Again, at the end of the day, there's plenty of reasonable suspicion that certainly justified Officer Traverso to investigate for OWI. Unfortunately for Officer Traverso, that suspicion never gave rise to cause in this case, and so therefore the PBT was improperly requested to be administered. The chemical test was improperly requested, and the arrest should be suppressed since it lacks probable cause. Thank you.
I will note, Your Honor, that Brother Counsel had failed to leave off his list of elements there, that there was an open bottle of liquor in the front seat of the car, a cup that was purported to possibly contain liquor, and to address the nystagmus and walk and turn tests, the nystagmus test first. The defense has repeatedly referred to these National Highway Safety Agency regulations, which were not entered into evidence here today and are not properly before the court. Not only that, but the statement that only 2 clues were noted on the HGN is rather pedantic, because they're relying on the fact that he didn't say specifically in the right eye and in the left eye. He just said in the eyes.
Are you saying on the report? Is that what we're talking about?
In
On
the
affidavit?
search warrant,
On the search warrant, which is not before the court.
it is, the affidavit and warrant are before the court.
Okay, it was never published.
So he did have more than 4 clues when you include right eye. If you include eyes to mean, as a normal person would, both eyes, not right eye and left eye individually. So only when they're citing from People v. Mullen, 282 Mich. App 14, only when there have been material omissions necessary to the finding of probable cause may the resulting search warrant be invalidated. Case law is also quite clear in Michigan that a great amount of deference is to be given to search warrants as opposed to a finding of probable cause based on a present sense or any other exception to a warrant. So, Your Honor, we have a probable cause standard here, and probable cause is to be a practical, non-technical conception judged from the totality of circumstances before the arresting officer. That comes from People v. Cone, which is 294 Mich. App 70. Based on the totality of the evidence in front of Officer Traverso, which was a running of a red light, the smell of intoxicants, the presence of liquor in the front compartment of the vehicle, the failed HGN tests, and the failed heel-toe, which I would state there's no way of telling, obviously, from the video what a half inch versus an inch is, but also in his, he had no chance, Officer Traverso had no chance to tell Mr. Miggins not to proceed at the very beginning. He said, "You're gonna stand like this," and he immediately started doing the heel-toe walk. So I would say that that is also an example of starting early. I'm giving both clues relevant for the walk and turn. However, as I've stated previously, even if you were to ignore the SFSTs, this is not analogous to the cases presented by defense counsel, because we don't have just the smell of intoxicants or just the intoxicants in running the red light. We have the smell of intoxicants running the red light, the presence of liquor in the front passenger compartment of the vehicle, the admission of Mr. Miggins that he had been drinking earlier that evening,
All of those exist outside of the world of the SFST and is more than enough for probable cause for arrest. Thank you, Your Honor.
Any re-argument?
No, Your Honor.
Do you all want to publish your exhibits?
Yes, Your Honor. Defense would like to admit defense exhibit A for the record, Your Honor, and defense exhibit B for the record.
Thank you. I am actually gonna set the, he can keep that because I
Okay.
think I know what, I think I found what he has there. That was really more or less for his benefit, not mine, but it's a scoring card. And I don't think, well, let me have somebody make a copy because you need that, correct?
Yeah.
Let me have somebody make a copy for you. And I'm gonna set this for a 1 week. I'll give my ruling. I have to go over this evidence. And I need to review the case law that was cited. November 14th at 10:30 work for you?
I think so. Did you say 10:30?
Correct.
I'm actually down in Mason at that time. I am available later that day, however.
2 o'clock works.
Yes, we're gonna make that work. Yes, Your Honor.
Okay, we will adjourn this until 2 p.m. on the 14th of November.
Thank you, Your Honor.
No problem. Any additional matters today?
Nothing further from the defense, Your Honor.
Nothing from the city, Your Honor.
Thank you. We're all set. I think I need the city to give me this. I can't stick this in my computer.
I can email you the video, Your
Okay,
Honor.
perfect.
Oh, that works.
We can't stick foreign things in the city. I don't know if it has a virus on it or not.
Appreciate it.
Okay, so that's that.
Get on your